Counsel is only matter of persuasion. Law is matter of injunction. Counsel acts only upon the willing. Law upon the unwilling also. It is also called a rule, to distinguish it from a compact or agreement. For a compact is a promise proceeding from us. Law is a command directed to us. The language of a compact is, I will, or will not, do this. That of a law is, thou shalt, or shalt not, do it. It is true, there is an obligation which a compact carries with it, equal in point of conscience to that of a law. But then the original of the obligation is different. In compacts, we ourselves determine and promise what shall be done. Therefore, we are obliged to do it. In laws, we are obliged to act, without ourselves determining or promising anything at all. Upon these accounts, law is defined to be a rule. Municipal law is also a rule of civil conduct. This distinguishes municipal law from the natural or revealed, the former of which is the rule of moral conduct, and the latter not only the rule of moral conduct, but also the rule of faith. These regard man as a creature, and point out his duty to God, to himself, and to his neighbor, considered in the light of an individual. But municipal or civil law regards him also as a citizen, and bound to other duties towards his neighbor than those of mere nature and religion, duties which he has engaged in by enjoying the benefits of the common union, and which amount to no more than that he do contribute, on his part, to the subsistence and peace of the society. It is likewise a rule prescribed, because a bare resolution, confined in the breast of the legislator without manifesting itself by some external sign, can never be properly a law. It is requisite that this resolution be notified to the people who are to obey it, but the manner in which this notification is to be made is matter of very great indifference. It may be notified by universal tradition and long practice, which supposes a previous publication, and is the case of the common law of England. It may be notified viva voce by officers appointed for that purpose, as is done with regard to proclamations, and such acts of Parliament are appointed to be publicly read in churches and other assemblies. It may lastly be notified by writing, printing, or the like, which is the general course taken with all our acts of Parliament. Yet, whatever way is made use of, it is incumbent on the promulgators to do it in the most public and perspicuous manner, not like Caligula, who, according to Dio Cassius, wrote his laws in a very small character, and hung them up upon high pillars, the more effectually to ensnare the people. There is still a more unreasonable method than this, which is called making of laws ex post facto, when, after an action is committed, the legislator then for the first time declares it to have been a crime, and inflicts a punishment upon the person who has committed it. Here it is impossible that a party could foresee that an action, innocent when it was done, should be afterwards converted to guilt by a subsequent law. He had therefore no cause to abstain from it, and all punishment for not abstaining must of consequence be cruel and unjust. All laws should be therefore made to commence in futuro, and be notified before their commencement, which is implied in the term prescribed. But when this rule is in the usual manner notified or prescribed, it is then the subject's business to be thoroughly acquainted therewith. For if ignorance of what he might know were admitted as a legitimate excuse, the laws would be of no effect, but might always be eluded with impunity. But further, Municipal law is a rule of civil conduct prescribed by the supreme power in a state. For a legislature, as was before observed, it is the greatest act of superiority that can be exercised by one being over another. Wherefore it is requisite to the very essence of the law that it be made by the supreme power. Sovereignty and legislature are indeed convertible terms. One cannot subsist without the other. This will naturally lead us into a short inquiry concerning the nature of society and civil government, and the natural, inherent right that belongs to the sovereignty of a state, wherever that sovereignty be lodged, of making and enforcing laws. The only true and natural foundations of society are the wants and the fears of individuals. Not that we can believe, with some theoretical writers, that there ever was a time when there was no such thing as society, and that, from the impulse of reason, and through a sense of their wants and weaknesses, individuals met together in a large plain, entered into an original contract, and chose the tallest man present to be their governor. This notion of an actually existing unconnected state of nature is too wild to be seriously admitted, and besides, it is plainly contradictory to the revealed accounts of the primitive origin of mankind, and their preservation 2000 years afterwards, both which were effected by the means of single families. These formed the first society, among themselves, which every day extended its limits, and when it grew too large to subsist with convenience in that pastoral state, wherein the patriarchs appear to have lived, it necessarily subdivided itself by various migrations into more. Afterwards, as agriculture increased, which employs and can maintain a much greater number of hands, migrations became less frequent, and various tribes, which had formerly separated, reunited again, sometimes by compulsion and conquest, sometimes by accident, and sometimes perhaps by compact. But though society had not its formal beginning from any convention of individuals, actuated by their wants and their fears, yet it is the sense of their weakness and imperfection that keeps mankind together. That demonstrates the necessity of this union, and that therefore is the solid and natural foundation, as well as the cement of society. And this is what we mean by the original contract of society, which, though perhaps in no instance it has ever been formally expressed, at the first institution of a state, yet in nature and reason must always be understood and implied, in the very act of associating together, namely, that the whole should protect all its parts, and that every part should pay obedience to the will of the whole; or, in other words, that the community should guard the rights of each individual member, and that, in return for this protection, each individual should submit to the laws of the community, without which submission of all it was impossible that protection could be certainly extended to any. For when society is once formed, government results of course, as necessary to preserve and to keep that society in order, unless some superior were constituted, whose commands and decisions all members are bound to obey, they would still remain as in a state of nature, without any judge upon earth to define their several rights, and redress their several wrongs. But, as all the members of society are naturally equal, it may be asked in whose hands are the reins of government to be entrusted. To this the general answer is easy.